See, Miss Malfino,
Yes.
on Tyree Hartley, Mr. Wilkerson sent a message that he's not going to be able to be here today.
So
He's announced ready. What is your announcement?
I really needed to speak with him this morning about an additional piece of discovery that I think he doesn't realize he's lacking. It's all that stuff we spoke with you a week or so ago about, but from chamber, it's
Oh.
4 agencies involved and
Right.
need to make sure that I can get back with Wendy today since he's out. I also have 2 of my lead detectives from Beaumont have sent in notice that they're on vacation all that week, but I don't want to announce not ready until maybe I can speak with him and see if he would stipulate to a couple things, but I didn't
Okay.
represent that I'm ready.
Gotcha.
Can I be ready for each, maybe
Sure.
for the time being until I can speak with him?
Yes, yes, ma'am.
You haven't?
Ready.
No, I said I'm not ready at all. He was ready. Ready to see.
Mr. Macon, you've got a Brian McWade.
Yes, Your Honor. He's a plea. He's done.
So that Hartley will reset. Yes, thank you. Sorry.
Good
Morning.
morning, Your Honor.
Morning, Your Honor.
Good morning.
No.
Good morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. We're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure.
Okay, I'll be sure to add it.
Mr. McWade, in cause number 26 DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony attempted aggravated assault with a deadly weapon from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them? Yes or no?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry. There would be an 8-year term in prison that would be
Which
probated.
I
for
believe
8
we can
years.
do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
I,
a little bit.
a little bit, yes, Your Honor. That's
Okay.
my understanding.
All right. So what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed
It's
to.
in that big green book, I think.
I'm sorry.
It's in that big green book.
Yeah,
The big green
the
book.
big green book. All right. So it looks like the agreement is for an 8, you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a
Saw
restitution.
the word
center.
restitution, check the box.
So there's an agreement. I'm going to write that you would pay restitution. Is that correct? And the amount determined between now and sentencing?
Yes, Sean.
Is that, you understand that as well? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount. And we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
He already served 150 days in jail for this case. We don't propose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway, you can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Let's make it.
Could you please make a note? Because I feel like I'll probably be on that. Take some. Your name. To remind me, and I can ask Ken to help me out with that. Yeah, give me 1 second. What you got?
I'm in trial next door.
Okay,
And we're getting ready to get started in a minute, and I think Tommy has some redacted stuff for me to look at, so I need to get over there.
okay.
But, the
You have a
pre-trial,
lot of them. over
I
there.
know, the pre-trial case that I had that's on the trial docket. Josh Smith,
Yes,
Mr. Smith just gave me a new offer that's gonna resolve that matter. I just
Okay.
need the time to do paperwork and everything to get it done. It's gonna be a probation plea.
okay.
I don't know if I'll be done today, but if we can do it next, if there's some available next week.
Well, no, well, we could do it Wednesday of next week. Or we could do it early tomorrow. No. Let's set it for a plea Wednesday morning of next week. Yes. Joshua Smith, well, so all of Mr. Lewis's are reset now. Okay,
Sorry about that.
that's okay. We could have not brought them all over, which we know. Okay, but that's fine. All right, so I will set that one though for a plea on Wednesday morning. Yes, sir. Well, that just, no. We may need to have like a. No, that's okay. Maybe we can look at all of those that are based Mr. Smith's, who's gonna have to be here Wednesday anyway. Of next week, we're setting some of those to that is have so many. And it's. I don't know if there's, you know what I mean? And then spread them out a little bit.
Thank you.
Okay, that's, Mr. Kelly, you've got Dondre at Blewett.
Yes, sir. Thank you.
Morning.
That's gonna go. Taking these 2 minutes. I guess not.
I've asked Mr. Coleman from the scope of the, yes, sir.
What did you do?
Your complaint witness, stood like recently.
Not worried now.
Good morning, you're Dondre Blewett.
Yes, no.
And Mr. Blewett's case in cause number 26 DCCR 0362 set for trial to begin with jury selection on August 17th. And what is the announcement?
Your Honor, I recently asked Mr. Coleman for some additional discovery involving a complaining witness. I sent him an email on. This was Thursday, the 30th. I haven't heard back from him yet. I think it's pertinent to our case because of what it involves a complaining witness. So until I have an answer on that, I don't think I can make an announcement.
Mr. Mickelson.
I show that some reports were added back in April, but nothing in the last week. So I'll have to check on that, Judge.
Okay.
I don't mind chasing him down. I know he's not in your court anymore. That's been.
Yeah, we're working on some of those issues. So why don't I do this? I'm just going to I'm not going to reset it at this point. If you can get with Mr.
got
Coleman,
nomination.
we've
I
got
can
2
submit.
weeks for you guys to, if you'll kind of help out with that, get that information to Mr. Kelly, and then kind of let me know where we are. It's not the trial oldest one, but others are kind of falling apart, so you never know. Yeah, so I'll number it, but I'll also make a notation of that.
Thank you.
Thank you,
Thank you.
Mr. Nichols.
Sure, thank you.
You can go back with the bailiff.
Mark.
I was supposed to get noticed.
And is that one that Mr. Coleman intended on keeping?
It originally was, yes, Your Honor. We can handle it.
Okay, thank you.
Looking back, I was just grateful.
Mr. Burbank on Kavon Saunier.
I guess they're all back.
They are. I hope he is.
Yeah. Just so they pick it up.
Thank you. I appreciate that. How are you this morning?
I am in a jury trial in CC two.
Hmm, all right. Good morning. Are you Kavon Saunier?
Yes, ma'am.
And Mr. Saunier's case in cause number 25 DCCR 1530 is set for trial to begin with jury selection Monday, the 17th of August. And what is the announcement?
Judge, the state's ready. On the 16th of July, I filed a notice of intent to use business record affidavit. There's about 1,200 pages of medical records that have been added to discovery a few weeks ago. I'll, in candor to the court, we'll have to proceed most likely without the complaining witness. And that's how we're going to be presenting this case.
Okay,
So we can be ready.
okay, sounds good. And that was done a few weeks ago?
I believe the 16th was when it was filed.
Okay, Mr. Burbank?
Your Honor, if you would call the 260th court, I do have a trial set. In Judge Raquel, it's a murder trial.
Okay.
And I can be ready, whoever wants me.
Okay, sounds good. I'll look at our numbering on this one and take that into consideration. And if for some reason it looks like you're at the top, I'll see how old that one is and things like that. And we'll work it out and let you know.
Yes, sir.
All right, thank you. You can go back with the bailiff.
Yeah.
Okay, Ms. Perazzo, you have Brandon Creation. Good morning. How are you?
We haven't had a case for mine that has been.
Good morning, sir. You're Brandon Creation.
Yes, ma'am.
And this is cause number 26, DCCR 1178. Mr. Creation is charged with murder. And what is the announcement?
Your Honor, there are a couple of things, couple of items that are missing, not that it's the state's fault that I need to request. And there's also a guardhouse video that I'd like to schedule a time to be with Mr. Creation.
Okay. And go ahead.
I'm sorry
Yes,
to
ma'am.
interrupt. I certainly concur with Ms. Perazzo about that. I am still in the process of receiving discovery. Some scientific lab paperwork came in a week or so ago. We made sure to add that to the portal. This also involves the conflict we mentioned to the court yesterday that we've resolved with another individual who was before you that is a family member. So now that we have cleared up that issue, if you'll recall what I'm talking about, and I can fill you in on it later.
Yeah.
It would allow me the opportunity now, as is my custom, sit down with the family. I wanted
Yes.
to do that before the court first, before I set that meeting, but I would like a
Okay.
chance to do that, make sure if Ms. Perazzo, as she usually does, sends me a list of what she needs, we'll go through our files together.
Okay, well, sounds good. And so what we'll do is just get with Ms. Holmes and we'll have Mr. Creation brought over. You guys can watch
make
that
that
video down here in the jury room in the next couple of weeks and get everything hopefully together between now and that next court date. And we'll see where we are at the next court date.
Yes,
All right, you can go back with the bailiff, sir. And then you have Thaddius McCrae.
This sentencing hearing quickly turns into one of the most important moments in Brendan Ernest's case. After previously entering guilty pleas to aggravated robbery, obstruction or retaliation, and robbery, everyone in the courtroom expects the judge to consider the negotiated agreement. But before making a final decision, Judge Raquel West carefully reviews the pre-sentence report and additional jail incident reports that raise serious concerns about the defendant's conduct. The defense argues that Brendan Ernest is only 17 years old and deserves another opportunity, while the court weighs the seriousness of the offenses against the information now available. At this stage, the question is no longer whether the defendant committed the crimes, but whether the proposed agreement truly serves justice and protects the community.
So we could.
Is there anything else that you guys are waiting on at this point?
Not that I'm aware of.
Okay.
They have produced everything. but I-
Perfect. So what we'll do, this will be the last reset. Ms. Perazzo will be out to see you to go over everything that she has received from the district attorney's office, relay whatever offer there is. When we come back, if there's an acceptance of that offer, we'll take care of it. If not, we'll get you placed on the trial docket after that.
Yes,
Okay?
Thank you so much.
Yes, ma'am. You can go back with the bailiff.
Oh, yeah.
Mr. Rojas, you've got sentencings on Brendan Ernest.
Morning.
Good morning. How are you?
Good. For now.
Good morning, you're Brendan Ernest. And Mr. Ernest was previously in court. Look at this way, pay attention to me. And cause numbers 26 DCCR 0429, 0430, and 0908. Entered pleas of guilty to aggravated robbery, obstruction or retaliation, and robbery. I've received the pre-sentence report. Have y'all both had an opportunity to review that report?
We have, Your Honor. Yes.
In addition to that, I've received and reviewed jail incident reports. Have y'all had an opportunity to review those?
We have. Yes, Judge.
All right, I am not inclined at this time to accept this plea agreement. based on the information of the offenses themselves, as well as the additional information that the detective has relayed with regard to all of the things that Mr. Ernest has been involved in, as well as what he's doing out at the jail. So y'all want to talk to me about
And
how to
Judge,
change my mind?
I don't know that this is gonna change your mind, but I meant to object to the part of Officer Jackson's statement as far as any uncharged conduct that happened while he was a juvenile in 2023.
I think that it's relevant and it's information that's important for me to know. If he's had contacts just because he was a juvenile and certain people didn't follow through because he was a juvenile and wanted to give him that opportunity, I don't think he gets to now say, well, I didn't get in trouble, so because somebody was nice and gave him some opportunity back then.
Well, then what I would say, Judge, is this is a youthful offender. He's 17 years old. These are his first cases. Some juvenile history that like it was successful completion of probation. He's never been on probation as an adult for either a felony or a misdemeanor. The alternative, Judge, I know is prison. And certainly there's a lot of violent crime going on in our community. It's for a first offense. I have a hard time sending people to prison for their first offenses, even though these are serious offenses. Some of them do deserve to go to prison for the first offense, but a 17-year-old first contact as an adult, I would ask the court to consider following the agreement with some sort of, I know the probation recommends MRT. I've also talked with Mr. Ernest about ISF, and he's
Here
willing.
you go. 17.
Yeah.
So here's my thought on something like this, based on the nature of these offenses and based on what he said to the police that day, which gives me a huge amount of concern. I'm not going to repeat the words here about what he said he was going to go back and do to that clerk. I'm not letting him out on today, not doing it. If a jury wants to do that, I'm not one to throw things on y'all know how I am about my trial docket. I'm not inclined to just throw things on the trial docket, but I think this is one for the community of Jefferson County to decide instead of us, because I'm not going to give them probation. If they choose to do that, then that's going to be up to them. But I don't think this is in any way someone deserving of probation, regardless of his age, at least at this time. If he had been not acting like a fool in jail, maybe I'd decide differently. But he hasn't changed anything. You haven't changed anything. I'm talking like you're not here. You haven't changed anything about your behavior. You're out in our jail, acting like an idiot with the rest of the youthful people out there, doing nothing but giving those people that are going to work every day crap. And if you think that's going to get you somewhere and you're going to get to go home today, now you see what it's going to do. It's not. You're going to get set for trial. And when you come to trial, if you're found guilty of these offenses, a jury's going to get to see all of that information about how you're acting at our jail. So you need to keep that in mind between now and when you come back to trial, because if you're going to be asking a jury to give you probation and you've been acting like this, highly unlikely. All right. So what I'm going to do is I'm going to set it on the trial docket. Mr. Ernest, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I'll appoint another attorney today who can begin preparation for trial a little quicker. Is that okay with you?
My decision.
Yep. If you want to keep Mr. Rojas, you can keep him. If you want to get someone else, you can ask for that as well.
Okay.
All right. So Mr. Rojas will begin preparation for trial. And, there's things, if y'all want to go to a jury for punishment only and accept responsibility, that's an option, but talk to him about that. But I'm not going to do it. All right. Thank you. I appreciate what y'all did. And I don't like getting involved too much in these negotiations,
The
but
offer was obviously made because of his age.
sure. No, I completely understand that. And I know you didn't know probably all the information, Mr. Smith, once it came out in the pre-sentence report about some of the specific facts of the case, as well as some of that history that gives me concern, as well as this jail stuff. So I'm not saying you shouldn't have given the offer. I'm just saying there's a lot of things you probably didn't know as well. So, all right, go back with the bailiff. Shannon Jones, Mr. Rojas.
We don't have, there's no,
Oh, not yet. Okay, I'll hold that. What about Lorenzo Thomas?
We need to approach and, well, it's Miss Malpino's case.
Did Ashley step out?
She stepped out, she should be right now.
Okay, thank you. Are you Shannon Jones? All right. And Mr. Rojas, will Mr. Jones waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jones, in cause number 26 DCCR 0842, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from March 13th of 2026. Your indictment alleges that you were previously convicted of theft February 8th of 2012, and then again June 3rd of 2013. And how do you plead to that charge?
Yes.
Not guilty?
Guilty.
Guilty. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find those 2 prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions, sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yeah.
All right, good luck to you, sir. You can go back with the bailiff. And then you've got Lorenzo Thomas.
Lorenzo Thomas.
What are we doing on this one?
There's some new offenses.
We just need to some time. Okay.
I just want to let you know what all it has in addition to the motion.
Okay.
Decide if we were just gonna stay or go elsewhere.
Good morning, sir. Are you Lorenzo Thomas?
Yeah.
And this is cause number 2240120, and Mr. Thomas is on probation for aggravated assault with a deadly weapon, and there's a motion to revoke that unadjudicated probation. What is the announcement?
Judge, it's coming to the attention of the state through Mr. Burrell that the defendant has, in addition to the Jasper County cases alleged in the motion, a new offense of evading detention felony in Harris County. I believe felony, Harris County. There's an active warrant for that now. I can either file a first amended motion to include that now that we have that offense material. We can allow him to go on that warrant, whatever the court wants to do, or go through this motion and see where we are. And I can still add it, but we kind of know where we were, whatever you want me to do.
I mean, I guess if it is this going to be the state's position based on all of that for me to revoke
Yes, it
the
will be.
probation, then I think I need all the information. So first amended would probably be the best way to go. I know getting officers from Harris County might be difficult, but my thought is let's get it filed.
Okay.
Get an offer, get whatever discovery materials you can get on that to Mr. Rojas. If there's an agreement at the next court date, great. If not,
So
we'll get pleas of true or not true and then set a hearing and see who you can get to come. Possibly, and if there's an agreement to take any witness on Zoom, we can still do that. Especially on these hearings, but if that would be up to Mr. Rojas, you guys, and I'm not trying to pressure you to do it, but y'all can visit about that. And if that's an option, we can take some certain things up that way as well.
sure, I'll get it filed this week.
Perfect. All right, we'll just do a reset then for that. Thank you, Mr. Burrell. Good to see you. Thank
Thank you, Judge.
Gotcha. All right,
Oh, who's this?
Christina Rodriguez. This is Miss French. Good morning, ma'am. You're Christina Rodriguez.
Good morning.
And this is cause number 17-27256. I'm going to take judicial notice of the court's file. You have paper though?
We're gonna go through the motion.
Okay.
You can say if you.
And in the file, Ms. Rodriguez was examined for competency to stand trial by Dr. Capon. I received that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Then at this time, I am going to find Ms. Rodriguez is competent to stand trial. We'll move forward and will she waive the formal reading of the motion?
Yes, Your Honor.
And Ms. Rodriguez, did you swear her in?
Yes.
Okay. Usually you don't if there's no paperwork, so I was just making sure.
Right.
Gotcha. Thank you. Ms. Rodriguez, in clause number 17-27256, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 16th of 2018 for injury to a child, elderly, or disabled individual, a second-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of terroristic threat, October 23rd of 2025 in Orange County, Texas. And is that true or not true?
That's not true.
Count 2 alleges that you committed the offense of harassment on October 23rd and 2025 in Orange County, Texas. And is that true or not true?
No, that's not true.
Count 3 alleges that you failed to avoid injurious or vicious habits as directed on December of 2025. You disrupted and created disturbances at the Tiger Hut in Silsbee, Texas by calling, harassing, threatening, and posting falsehoods on their business website. Is that true or
That's
not true? Count 4 alleges that you're behind in your court assessed fees as of March 26th of 2026 in the amount of $9,198.39. Is that true or not true?
That's true.
All right, then, did you enter your plea of true to count 1 freely and voluntarily? 4, I'm sorry, count 4 freely and voluntarily. And did you plead true to that count because it's actually true?
It's true.
Then at this time, I'm going to find count 4 true, find that you entered that plea freely and voluntarily. Reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. Ms. Malfino,
Judge, Ms. French has a detailed witness list already prepared. I'll make sure that goes out whatever date the court gives me today. And if she's in trial and something else, I've had it.
so that'll probably need to have a little bit, a couple of hours, I would think, not just a short.
Like maybe you have 4 witnesses.
Okay, so we'll get it set on a date when we have plenty of time. Anything that you think is important for Ms. Holmes to know, get that information to her. She'll present it to me on your behalf when we come back and we'll set it for a hearing.
Yes, ma'am.
Okay, you can go back with the bailiff.
Okay.
Here is where everything changes. Rather than immediately accepting the negotiated plea agreement, Judge Raquel West explains that the court must consider more than just the defendant's age. She points to the facts of the offenses, statements reportedly made after the crimes, and the defendant's behavior while in jail as reasons for concern. In a sentencing hearing, judges may reject an agreed recommendation if they believe it does not adequately reflect the circumstances presented before the court. Do you think a defendant's age should outweigh serious criminal conduct when deciding probation? With that question hanging over the courtroom, the hearing moves toward a decision that will dramatically alter the course of this case.